The Supreme Court chamber grew completely still as Justice Stephen Breyer leaned forward in his seat. Every person in the room had their attention locked on 43-year-old Congresswoman Jasmine Crockett, who stood firmly at the podium. What began as a routine discussion on voting rights was suddenly turning into a moment that would be remembered for decades. "Congresswoman Crockett," Justice Breyer said, his voice echoing through the silent courtroom. "In my 27 years on this bench, I have never heard an argument delivered with such clarity and constitutional accuracy." Instantly, the room changed. The justices went motionless. Lawyers shifted in disbelief. The gallery buzzed with whispers. Hardly anyone could recall a Supreme Court justice openly praising an advocate during oral arguments, especially someone presenting her. First ever case before the highest court in the country. But what Congresswoman Crockett said next didn't just acknowledge his compliment, it completely shifted the direction of the entire case and left Justice Breyer at a loss for words, something almost unheard of in his long career. Before we uncover the moment that stunned the courtroom, make sure to hit the subscribe button and turn on notifications. You won't want to miss our breakdowns of the legal battles currently shaping American policy and democracy that crisp October morning. The marble corridors of the Supreme Court were filled with anticipation. Law clerks rushed through hallways carrying stacks of briefs. Reporters gathered in small groups, quietly guessing what might happen. Security officers guided the long line of citizens hoping to witness the widely followed voting rights case. The lawsuit, Johnson v. Texas Election Commission, questioned a Texas voting policy that had shut down more than 300 polling sites in mostly minority communities. A conservative appeals court had upheld the law, and many analysts considered the Supreme Court appeal a long shot. What made the case even more unusual was the person chosen to argue it. Congresswoman Jasmine Crockett of Texas's 30th District had requested special permission to present the argument herself. With years of civil rights experience and major victories in voting rights cases, she had a personal stake in the matter. Many of the closed polling sites were located in her own district. Justice Stephen Breyer, at age 83, symbolized the traditional core of American judicial thinking. A graduate of Stanford, Oxford, and Harvard Law School, he had spent more than 2 decades shaping rulings on issues like affirmative action and the death penalty. Known for his detailed hypothetical questions, he was famous for challenging attorneys with complex scenarios and demanding explanations grounded in real-world impact. Impressing him was no small task. Standing across from this veteran jurist was Congresswoman Crockett, representing a new era of leadership. Raised in St. Louis in a middle-class household, she worked her way through Rhodes College and later earned her law degree from the University of Houston. Before entering Congress, she built a strong reputation as a civil rights lawyer, taking on cases involving voting rights, police misconduct, and justice system reform. She secured several major wins, including a $4.5 million settlement for a family whose son was wrongfully killed by police. What made Crockett a formidable opponent was her combination of passion and meticulous preparation. She wasn't just a powerful speaker, she was an organized, detail-oriented legal strategist who always arrived with documented facts, legal precedent, and a deep understanding of procedure. The case carried massive consequences. Although the Texas law didn't openly mention race something, lawmakers avoided it used a complicated formula based on previous voter turnout, local tax revenue, and so-called efficiency metrics. In practice, this formula caused hundreds of polling places in Black and Hispanic neighborhoods to shut down. Meanwhile, wealthier white communities kept their polling centers or even saw an increased dot in certain areas. Residents were now forced to travel nearly 20 miles just to cast a balota. Serious obstacle for thousands without reliable transportation. What do you think about the Supreme Court taking on more voting rights cases in recent years? Do you believe they're doing enough to safeguard every voter? Share your thoughts in the comments section. We want to hear your views on this critical issue in our democracy. Inside the courtroom, the energy was intense as Congresswoman Crockett stepped up to speak. She wore a simple navy suit, her hair neatly tied back, holding only a small binder. Her calm presence contrasted with the magnitude of the moment, a sitting member of Congress appearing before the highest court on an issue affecting millions of Americans. Double quotes Ms. Crockett. Chief Justice Roberts began, "You argue that this Texas law violates Section 2 of the Voting Rights Act, as well as the 14th and 15th Amendments? But the law never references race. It applies its criteria uniformly across all polling locations in the state. How do you prove discriminatory intent?" "Mr. Chief Justice," Crockett replied confidently, "the Supreme Court has long established that discriminatory intent can be shown through the factors identified in Arlington Heights v. Metropolitan Housing Corporation." She explained each factor clearly: the historical context, the events leading to the policy, departures from normal procedures, and the effects of the law. Then she added, "In this case, we have documented evidence supporting all four." With steady precision, she walked through each factor and connected it directly to the Texas law, citing page after page of evidence from the case record. Justice Clarence Thomas leaned forward. "Congresswoman Crockett," he said, "even if we accept your application of Arlington Heights, the state maintains that these closures were necessary for budget reasons. Doesn't that amount to a legitimate state interest?" Justice Thomas asked. "Justice Thomas," Crockett replied, "if saving money were the actual goal, then the state would have reduced polling locations evenly across all regions. Instead, 93% of the closures occurred in communities where more than half the voting age population is made up of minority residents. And according to the state's own financial report, these particular closures save just 0.3% of the election budget, yet they impact nearly 27% of all registered voters." Her precise answer and the fact that she cited exact numbers without looking at her notes made Justice Thomas lift his eyebrows. Justice Amy Coney Barrett jumped in. "Let's say you've shown disparate impact. The Fifth Circuit still ruled that the state's interests were compelling under the Anderson-Burdick balancing test. Why should we say they were wrong?" "Justice Barrett," Crockett responded, "the Fifth Circuit made a critical mistake in its Anderson-Burdick analysis. They ignored real-world evidence of the burden. This court in Crawford v. Marion County emphasized that the balancing test requires factual proof, not speculation." She reached into her pocket and pulled out a small device. "With the court's permission, I'd like to demonstrate something." The justices exchanged curious glances and nodded. Crockett pressed a button, and a projection displayed a map showing a long, winding route. "This GPS device recorded an actual voter's trip to the new polling site," she explained. "This 17.3-mile journey took a 72-year-old resident of East Houston 3 hours each way using public transportation. That isn't a minor inconvenience. It's a complete barrier for thousands of elderly voters and working families." Justice Samuel Alito remained skeptical. "Congresswoman, one personal example doesn't establish a pattern of unconstitutional burden." "I agree, Justice Alito," Crockett said immediately, catching him off guard. "That's why we conducted a full transportation study for all affected districts. You'll find it in Exhibit 47. The analysis shows that 62% of impacted voters would spend more than 2 hours on public transit just to reach their polling place. For people with hourly jobs, caregiving duties, or health limitations, that is a severe burden, and the Fifth Circuit failed to consider it." For nearly 40 minutes, the rapid questioning continued. Each justice pressed her with detailed legal challenges. Yet Crockett answered every inquiry with sharp reasoning, documented evidence, and calm confidence. The more she spoke, the harder it became for the court to dismiss her position. Then came the turning point. Justice Breyer, who had been unusually quiet, finally leaned forward. "Congresswoman Crockett, let's explore a hypothetical." The room tightened instantly. Breyer's hypotheticals were legendary for their complexity. "Imagine," he began, "a state passes a rule that assigns voters with odd-numbered Social Security endings to location A, and those with even numbers to location B. Suppose this neutral Rule results in 90% of black voters being placed in location A, which also happens to be significantly farther away. Would that violate the Constitution if we have no direct evidence of racial intent? It was exactly the sort of multi-layered question capable of causing even veteran Supreme Court advocates to stumble. Everyone waited, watching to see how she would handle it. For the first time during her argument, Crockett paused. She took several seconds before responding, "Justice Breyer, your hypothetical describes a rule that appears neutral on its face but has an extreme disparate impact. This is similar to the situation in Yickwo v. Hopkins from 1886, where this court held that a neutral law applied in a discriminatory way violates equal protection." She continued, shifting into a broader point. "However, I believe your hypothetical exposes the deeper issue in this case. Texas argues that as long as they rely on race-related substitutes rather than directly mentioning race, then their actions can be unconstitutional no matter the outcome." Then she made an unexpected move. This court addressed a nearly identical tactic in Gamalion v. Lightfoot, where a bizarre 28-sided city boundary excluded nearly all black voters but not a single white voter. Even though geography was the stated criterion, the court recognized the boundary as purposeful discrimination. As Justice Frankfurter wrote, "The Constitution prohibits both simple and sophisticated forms of discrimination." Justice Breyer leaned even closer, clearly engaged. "That's accurate, Congresswoman. But in Gamalion, the discriminatory intent was obvious from the absurd boundary shape. How do we apply that to situations that aren't so blatant?" "The key, Justice Breyer," Crockett replied, "is determining whether the state's stated justification is genuine or a pretext. In Arlington Heights, this court provided a framework for identifying pretext by examining the historical context, procedural deviations, and the sequence of events leading to the policy." She continued without glancing at her binder. "In this case, we have evidence that the Texas legislature commissioned a private study on racial voting patterns before drafting the polling location formula. The study identified methods to reduce minority turnout without directly referencing race. These materials are documented in emails obtained during discovery." Justice Breyer wasn't satisfied yet. "Let's go back to your Gamalion comparison. What proof do you have that the Texas law's seemingly neutral factors past turnout, local tax revenue, these so-called efficiency metrics are just stand-ins for race?" This was the moment she had been waiting for. "Justice Breyer," Crockett said, lifting a single sheet from her binder, "we have the state's own statistical report." She held up the document. This regression analysis conducted by the Texas Department of State's data team before the law was passed shows a 0.91 correlation between the optimization formula and the percentage of non-white voters in each precinct. The courtroom erupted in murmurs. A correlation that strong was devastating, and in addition, Crockett continued, "we have sworn testimony from Dr. James Rogers, the very statistician who designed the formula confirming that he was directed to identify neutral-sounding factors that would produce the desired demographic outcome." As Crockett continued, something unusual began unfolding in the courtroom. Justice Breyer, normally composed and expressionless during arguments, was nodding ever so slightly. The subtle shift in his posture didn't go unnoticed. Several justices exchanged quick glances, and the entire atmosphere in the chamber tightened with anticipation. "One final question, Congresswoman," Justice Breyer said, his voice calm but intent. "If we accept your showing of discriminatory intent, what remedy are you actually asking this court to impose? Surely you don't expect the Supreme Court to manage the placement of every polling site in Texas." "No, Justice Breyer," Crockett replied firmly. "We're not asking for micromanagement. We're requesting that the court strike down Texas's formula and require any future polling place closures to undergo pre-clearance by a federal district court. This would ensure compliance with the Voting Rights Act and mirrors the type of remedy this court recognized in Shelby County v. Holder when facing fresh evidence of discrimination." Her allotted time was nearly gone, but Crockett pressed forward with a final, forceful statement. "The right to vote is the foundation upon which every other right stands. When lawmakers construct artificial barriers that keep citizens from accessing the ballot box, our democratic framework is weakened. The record shows the Texas law didn't accidentally create these obstacles, it engineered them. We respectfully ask this court to protect those fundamental rights and invalidate this statute. As the red light illuminated, signaling the end of her argument, Crockett stepped back. The room didn't immediately react. Instead, a deep, heavy quiet settled in a silence that carried the weight of what everyone had just witnessed. It was clear to all present that this was no ordinary argument. It was a moment destined for legal history. What happened next only cemented that impression, rather than moving straight to the next advocate. Justice Breyer leaned back, looked directly at Crockett, and spoke with unmistakable conviction. "Congresswoman Crockett," he said, his voice traveling through the stillness, "in my 27 years on this bench, I have never heard an argument delivered with such clarity and constitutional precision." The remark hit the room like a shockwave. Supreme Court justices do not give personal praise during oral arguments ever. Reporters scrambled to write, clerks stared wide-eyed, and the Texas Solicitor General froze in place. Stunned at the break in tradition, Crockett looked momentarily surprised but regained her composure quickly. Instead of basking in the compliment, she redirected the moment. "Thank you, Justice Breyer," she said softly. "But what matters most today isn't my advocacy. It's the constitutional rights of the 1.8 million Texans who now face barriers that make voting nearly impossible. Their voices, not mine, are what deserve this court's full protection." Her humility and sharp focus transformed the exchange from personal praise into a pointed reminder of what the case was truly about. Even Chief Justice Roberts gave a subtle nod. But Justice Breyer wasn't done. "Indeed, Congresswoman," he continued, "and that leads me to one more question. Correlation alone does not establish intent. What evidence do you have that the Texas legislature knew about or intended the racially disparate impact before passing the law?" Crockett answered without hesitation. "Justice Breyer," she said, holding up one finger, "we have three key pieces of evidence showing the legislature was fully aware of the impact and intended it." She extended a second finger. "First, the bill sponsor, Senator Williams, dismissed warnings about the effect on minority voters, saying, if they want to vote, they'll find a way. That statement appears in the legislative record." A third finger. "Second, emails between the governor's office and legislative leaders directly calculate how many Democratic votes would be reduced by the closure formula. Those emails outline the expected partisan benefit of targeting specific areas." And a fourth finger. "Finally, a former legislative aide testified under oath that lawmakers discussed using facially neutral criteria as stand-ins for race during closed-door meetings, specifically to avoid constitutional scrutiny." She lowered her hand, viewed. "Together, Justice Breyer, these pieces of evidence make the intent unmistakable. The legislature predicted the impact, wanted the impact, and crafted the law to hide that intent behind neutral terminology." The Texas Solicitor General jumped up, visibly rattled. "Your Honors, I must object. The Fifth Circuit found none of these claims credible." Chief Justice Roberts turned toward him, expression tightening. "Counsel, this is not a trial court. Objections are not appropriate here. You will have your opportunity to present your response." Embarrassed, the Solicitor General sat down. His mistake forgetting basic Supreme Court procedure revealed just how destabilizing Crockett's performance had been. Justice Breyer nodded thoughtfully. "Thank you, Congresswoman. You may return to counsel table." As she walked back, Justice Kagan leaned toward Justice Sotomayor and whispered something that made both women nod in agreement. Justice Barrett flipped hurriedly through the appendix, checking the email evidence Crockett had referenced. The shift in the room was undeniable. When the Texas Solicitor General rose to begin his argument, it was immediately clear the dynamic had changed. Gone was the usual polite, academic tone. The justice's questions came sharper, more direct, and far more skeptical, an unmistakable sign that Crockett had reshaped the entire trajectory of the case. Chief Justice Roberts opened the exchange. by saying, "Counsel, let's talk about the email evidence Congresswoman Crockett mentioned. Are you denying that the communications about the political impact of closing polling locations are real?" The state's attorney replied, "Your Honor, those emails talk about political effects, not racial ones. The legislature is allowed to consider political consequences. That isn't unconstitutional." Justice Kagan immediately stepped in. "But isn't it also true that in those same emails, the writers admit that race and party affiliation overlap heavily in the regions being targeted? One message even says that 90% of the burden will fall on minority residents, and that this result works out perfectly for their goals." The Solicitor General tried to recover. "Justice Kagan, that line was taken out of its full context. I have the complete thread with me." Justice Kagan lifted the printed page she was holding. "No, counsel. There's no missing context. In fact, the next sentence states, and I'm quoting, 'Best of all, we can justify this as cost-cutting if anyone challenges us.'" The Solicitor General visibly paled, realizing the justices had already reviewed the entire record in detail. Then Justice Thomas, normally silent during oral arguments, spoke. "Counsel, you are avoiding the core issue. Under Section 2, the question is not whether the state created the existing inequalities, but whether the voting system combines with those inequalities to deny equal access. What is your answer to that very specific legal requirement?" As the examination continued, it became clear that Crockett's careful preparation had redirected the entire conversation. Even justices who were expected to support the state raised sharp, uncomfortable questions. Justice Breyer delivered the most devastating one. "Counsel, let me ask you plainly. Are you arguing that a law which foreseeably and measurably blocks a large number of minority voters can still be constitutional as long as the text itself avoids racial language?" It was the kind of question no attorney wants to face. The Solicitor General tried to walk a tightrope. "Justice Breyer, our view is that a law with a legitimate governmental purpose, applied through neutral criteria, is constitutional unless there is unmistakable proof of discriminatory intent." Justice Breyer followed up. "What about the testimony from the legislative aide who described private meetings where substitute terms for race were openly discussed? How does that fit your standard?" The Solicitor General answered, "That testimony was deemed unreliable by the Fifth Circuit, Your Honor." Justice Sotomayor cut him off. "On what basis?" The district court judge, who personally heard and evaluated the witness, found the testimony credible. The Fifth Circuit dismissed it with no explanation. When the Solicitor General's argument time ended, Chief Justice Roberts turned to Congresswoman Crockett. "You have 4 minutes for rebuttal, Congresswoman." She returned to the podium, knowing this was her final chance to shape the outcome. The entire courtroom leaned in as she began. "Thank you, Mr. Chief Justice. I'll be brief." She paused, steadying her voice. "This court has long recognized that voting rights are the foundation of every other right we enjoy. When obstacles are placed in the way of that right, especially obstacles that fall most heavily on specific communities, our democracy is weakened." She looked directly at the bench. "The evidence here shows not only unequal impact but also purposeful discrimination disguised behind supposedly neutral rules. The emails, the witness statements, the data all reveal a coordinated plan to suppress minority voting while maintaining a public facade of fairness." Her tone grew firmer. "The question before you is not limited to polling places in Texas. It asks whether our Constitution allows modern, subtle forms of discrimination to succeed where older, obvious ones would fail." She let the words settle before continuing. "The authors of the 14th and 15th Amendments and the drafters of the Voting Rights Act understood that discrimination changes shape over time. They gave this court the responsibility to look deeper than surface-level neutrality and protect the right that safeguards all others. Today, we ask you to carry out that responsibility." As she stepped away from the podium, the courtroom stayed absolutely silent. Even critics of her position knew they had just witnessed a remarkable display of legal skill. Chief Justice Roberts ended the session with, "The case is submitted." The immediate reaction to the argument was striking. When Congresswoman Crockett walked down the marble steps, crowds of supporters, reporters, and legal commentators rushed toward her, eager to discuss what had just happened. A CNN legal analyst was already broadcasting live. This may have been the most powerful Supreme Court argument in decades. Congresswoman Crockett didn't just make a case. She dismantled the state's defense point by point with the command of someone who has argued here for years. Major. News outlets published headlines such as "Crockett stuns," "Supreme Court with masterful argument," and "Justice Breyer's rare praise suggests major victory for voting rights." Experts from across the legal world began weighing in. Harvard law professor Lawrence Tribe posted, "Congresswoman Crockett's argument today could reshape how courts evaluate discriminatory intent in voting rights cases for a generation." Even conservative analysts admitted her performance was extraordinary. Former Solicitor General Paul Clement stated on a legal podcast, "Regardless of where one stands on the underlying issues, the advocacy we saw from Congresswoman Crockett was truly exceptional." 3 weeks after the Supreme Court hearing, Justice Breyer announced that he would retire when the term ended. In his farewell statement, he emphasized the need to safeguard core constitutional principles and expressed optimism about the new generation of legal advocates stepping forward. When a reporter asked Congresswoman Crockett whether his retirement had anything to do with her powerful argument, she answered with her usual humility, "Justice Breyer has given decades of honorable service to this country. His legacy can't be tied to one case or one advocate. It comes from his lifelong dedication to a Constitution designed to protect every American." 2 months later, the Supreme Court released its decision in Johnson v. Texas Election Commission. In a surprising 6-3 ruling, Chief Justice Roberts joined the court's 3 liberal justices along with Justices Barrett and Gorsuch to strike down the Texas statute. Justice Breyer authored the majority opinion, creating a new legal test for identifying discriminatory intent in modern voting rights cases. The court held that when a law appears neutral but creates extreme and predictable harm for minority voters, judges must look past superficial explanations. Evidence showing policymakers understood and intended those unequal impacts, whether reflected in emails, data, or legislative timing, can reveal unconstitutional discrimination even without explicit racial wording, Breyer's opinion directly cited Crockett's oral argument. As counsel for petitioners clearly explained during argument, the Constitution prohibits subtle methods of discrimination as strongly as it rejects overt ones. From Gomelian to Arlington Heights, this court has reaffirmed that principle, which remains vital in an era where discriminatory practices evolve to appear neutral. Within a matter of days, voting rights organizations in 5 other states filed new lawsuits against similar laws, pointing to the Johnson ruling as binding precedent. Legislators in other states who had been considering comparable restrictions quietly abandoned their proposals. For voters in Crockett's district and throughout Texas, the ruling produced immediate change. The state was ordered to reopen closed polling sites and create a fairer distribution plan. When the next election arrived, voter participation in communities previously affected rose by 37%. 6 months later, Congresswoman Crockett delivered the keynote address at the American Bar Association's annual conference. Her speech, titled "Constitutional Advocacy in the 21st Century," quickly became required viewing in law schools across the country. "The Constitution's guarantees don't enforce themselves," she told the audience of attorneys. "They depend on advocates who understand both the big ideas and the fine details, who can link theoretical rights to real-world consequences. When we lose that connection, when technical points overshadow the fundamentals, we fail the very document we claim to respect." Her closing remarks were quoted widely. "The strongest force in constitutional advocacy isn't passion or politics. It's preparation. It's the careful work of analyzing the law, gathering the evidence, and presenting judges with a clear and honest path. That work isn't glamorous. It happens late at night, surrounded by documents, not in front of cameras. But when it's time to defend constitutional values, that preparation becomes power." Perhaps the most profound recognition came from Justice Breyer himself. In his final interview before retirement, a journalist asked which cases had most shaped his thinking. Breyer paused before answering. There have been many important cases, he said. But occasionally an argument clarifies constitutional principles in a way that shifts your perspective. The voting rights case presented by Congresswoman Crockett was one of those moments. Yet the most significant effects were felt far beyond Washington. Over the next several years, states across the country were compelled to reevaluate voting procedures that had long posed barriers for minority, elderly, and disabled voters. Access to the ballot expanded, participation increased. The democratic process grew more inclusive and reflective of the nation. Law schools began teaching the case alongside historic voting rights rulings, and constitutional textbooks included excerpts from Crockett's argument as an example of model advocacy. Young attorneys studied her methods to understand how preparation, clarity, and precision could influence the nation's highest court. For Congresswoman Crockett, the Supreme Court victory became both a defining milestone and the beginning of broader national influence. She continued her work in Congress with a new level of visibility, focusing on constitutional protections, court reform, and economic fairness. But she remained deeply connected to the communities she served. When asked whether she viewed herself as a constitutional figurehead, she shook her head with a smile. "I see myself as someone doing the necessary work. There are countless Americans whose rights are still vulnerable. The Constitution belongs to them, not just to judges, lawyers, or lawmakers. My role is to make sure its promises are real for everyone." The true lesson from that unforgettable Supreme Court encounter went beyond strategy or courtroom skill. It highlighted the impact of rigorous preparation, moral certainty, and dedication to foundational principles. It showed how much one person can achieve when deep knowledge is paired with unwavering advocacy. Those who witnessed that day still recall the moment vividly: a silent courtroom, a sharp legal mind, a thoughtful justice, and a constitutional value powerfully upheld. And for the millions of voters whose rights were strengthened because of the ruling, the legacy lives on in something even more essential: their ability to participate fully and equally in American democracy. If this powerful story of constitutional advocacy inspired you, make sure to hit the subscribe button and turn on notifications. We bring you the most crucial legal and political developments shaping America's future. Share this video with anyone who needs a reminder that preparation and principle can still prevail in the nation's highest courts. The fight for voting rights continues, and we'll be here to cover every pivotal moment.